issues in digital media, privacy, and data security. So GDPR is keeping us quite busy these days. So what are we going to talk about today? Well, we're going to spend a good deal of time comparing and contrasting the approach in the US versus the approach in the EU when it comes to data privacy. Because many of you are familiar with how to conduct business in the US, and you need to understand how radically different it's going to be under GDPR in the EU. We'll go through some key provisions, but we certainly can't go through all of it. Although, as Ross said, free legal advice. I'm happy to take questions at the end, and I'll be here just through early tomorrow morning, so get me before I leave. We'll talk about some pending legislation in the United States that could change things. Things are starting to creep into the laws in the US that will bring some concepts over from Europe. And like I said, Q&A, but you guys are going to be experts. This stuff is easy, right? So why are we concerned about this? Privacy. We all are in a business of collecting data and monetizing data and trying to activate data, and that raises lots of privacy concerns when we collect data. Let's start off with a quick video about how important data is. Volume?
Peter, come take a look at this.
Mr. Daniels.
Mr. Daniels.
Look at this.
What's this? The numbers, they keep getting bigger and bigger.
The clicks are off the charts.
Yeah.
Yoshi, it's Walter. We're back.
Yes, sir.
I need more trees. More trees? I'll get you more trees.
Hey, take a look at wood pulp.
Whoa. Everything you got on wood pulp right now.
He really loves that thing.
Okay, so data is really important, but getting it right is also really important. Privacy has been the buzzword for quite a long time. I love this quote from Scott McNealy, former CEO of Sun Microsystems. "You have zero privacy anyway, get over it." And that quote was from 1999. That's like in the Stone Age when it comes to digital. And he knew that the world was changing and the way that data is being collected and exploited. And a quote from an industry friend, Peter Shankman, says, "Men lie, women lie, children lie. The only three things that don't lie are data, pets, and spandex workout clothing." So data is critical, privacy is critical. So what's happening? There's a big difference between the US and Europe these days. We just have a very, very different approach to how data is being used. And we hear about the GDPR, the full name is up there, really, this regulation of the European Parliament, General Data Protection Regulation. It's a very lengthy law. In the United States, our law is basically one sentence. We have the Federal Trade Commission Act, which has one section, one sentence, which says unfair methods of competition in or affecting commerce and unfair or deceptive acts or practices are unlawful. It's this one sentence that governs privacy in the United States in general. There are different sectoral laws, but this one sentence is basically what governs everything. This also governs advertising, deceptive advertising. So to go ahead a slide and dig down into it a little bit, what is deception? Deception is basically saying something that is not true. If your privacy policy says, we will not share your personal information with a third party, and you do share it, that's deception. If you collect information and you have a security breach, the FTC will view that as unfair, that you may harm somebody by collecting their information and not keeping it secure. Again, it's one sentence. Lawyers like to focus on definitions a lot because definitions drive everything. And one of the challenges is in that in the United States, we have no definition of PII. We all run around in the industry saying, I collect PII, I don't collect PII, I'm going to match it to PII. That means nothing. There is no definition of PII. In Europe, there is a definition of personal data, and it's extraordinarily broad. And as we're going to dig into it, you'll see it covers everything. It covers everything. In the United States, we have some industry sectoral laws that define it. The Children's Online Privacy Protection Act defines personal information. HIPAA for health information defines it. GLB for financial. And there are individual state security breach notification laws that define it. But as a global concept, there is no definition of PII in the United States, while in the EU, there is a global definition of personal data. So I just said there's no definition, and personal identifiers are personal information in the EU, but not in the US. There is one law in the US that defines a persistent identifier as personal information, and that's under the Children's Online Privacy Protection Act. It's actually the only law in the United States right now on the federal level that defines a persistent identifier as personal information. Now, COPPA just applies to children under 13. So if you're dealing with a child under 13 online, by law in the US, a persistent identifier is personal information. Someone 13 and over, it is not by law. But our regulators want it to be that way. The FTC puts out lots of guidelines and blog postings and speaks quite often. And here's one blog posting which jumped out. They posted this after speaking at an advertising conference and got everyone very nervous. And they said, "We regard data as personally identifiable and thus warranting privacy protections when it can be reasonably linked to a particular person, computer, or device. In many cases, persistent identifiers, such as device identifiers, MAC addresses, static IP addresses, or cookies, meet this test." That's a blog posting. That's not the law. But that's what our regulators want. They want all this data to be treated as personal. All right, so let's dig into the GDPR a little bit more. So what is the GDPR? Well, it is a new law, and the way things work in the EU between regulations and directives is very different. A directive, we've been living under what's called the Data Protection Directive, is not a law that applies to all the countries. All the countries implement their own rules when it comes to a directive. The General Data Protection Regulation is a regulation. It is automatically law for all of the countries in the EU, unless they are given rights under the regulation to change things in their country. So it is one consistent law. And it is a biggie. It is huge. I mentioned how we have one sentence that governs privacy in the United States. This thing is 99 articles and 173 recitals, which are kind of preambles that give you insight into what the regulators are thinking. Enforcement begins May 25th, so less than a month away. Now that's enforcement. It's actually the law today, but enforcement doesn't begin until May 25th. That's when they can first start enforcing it. And why is this important to us? Well, it's important to us for many reasons, and it's important to you for many reasons. You might be putting tags on pages, you're doing cross-device tracking, you're matching data with other sources. All of these practices are implicated by GDPR. And what's the real reason it's very important? The penalties. The penalties can be very, very severe. They have the ability to impose fines up to 4% of your annual revenue worldwide, or up to 20 million euros. That's a lot of money. So you don't want to be the one who throws a tag on a page and gets your company hit with a significant fine such as that. So let's go through a couple of things. I said there's 99 articles in the GDPR. There's no way I can go through all of them. I'm just going to highlight a couple of key concepts that you should be aware of. So firstly, it's got an extraterritorial scope. We're sitting here in the US. Why do we care about GDPR? Because it applies to controllers and processors not established in the EU, where the processing is related to the offering of goods or services, you're selling things to folks in the EU, or you're monitoring the behavior of people in the EU. There's a lot of stuff in there to unpack. Well, firstly, controllers and processors. That's the EU term. The controller you might think of as the party that owns the data, the party that makes decisions about how the data is going to be used and exploited. So the processor is the one who's maybe a vendor, who's doing the work for them. It's a service provider, even a hosting provider. They are processors. Now, that's a very simplistic way of looking at it because you can be joint controllers, you both can be controllers, or you can be sub-processors, one passing off to the other. There's a lot of people that's involved in it. But sitting here in the US, if you're targeting folks in the EU, you're shipping things to the EU, or you're intentionally tracking folks in the EU, this can apply to you. For every processing activity of personal data, there has to be a lawful purpose. There are a number of reasons that can be a lawful purpose, but the two most common that everyone looks at are consent and legitimate interest. Consent, very easy. The individual has said, yes, you can process my personal data for this reason. Now, when you get consent, you have to get consent for every processing activity. You can't just get one blanket consent and then use it for lots of different things. You're supposed to get consent for every activity. Legitimate interest is kind of the don't be creepy factor, that you can process someone's data without consent as long as you don't offend the rights and freedoms of that user. So think of it as you can process the data if they expect you to process the data. Maybe you exchange a business card with someone at the conference here. It's probably reasonable for you to expect that person to contact you, because that would be a reasonable expectation. So it's not only consent. Personal data, I talked about how it's defined, and it can be anything. Online identifiers, location data. Children's data is going to be a real sticky issue because under the GDPR, they define a child as someone under 16. In the US, we define it as someone under 13. But this is one of the areas where the regulators said that individual member states can change the law themselves. They can decide to lower the age to 13, and many of them will, but they haven't done so yet. And the deadline is coming very soon. Then there's the concept of pseudonymization. And this is kind of what we do in the US mostly with data. The process of processing personal data in such a way that the data can no longer be attributed to a specific data subject without the use of additional information. So that might be hashing the data, and then you pseudonymize it. That doesn't mean you don't have to comply with the law anymore, but the obligations have gone down a little bit. It is still personal data. But the important thing is anonymous data, and this is where we have a big disconnect in the US and Europe. We always talk in the US about anonymizing data. And when we talk about anonymizing data, it's not what the Europeans mean. When they say anonymizing data, that means it's done. It can never be matched back to the personal data. You can't do it by getting a key to decrypt the hash. You can't do it by matching. It's done. It can never be. There are 150 people in this room. That's it. There's no identifier. So in the US, when we say anonymous, we're usually talking about pseudonymous information, that we could find a party and match it up. We all know that if we take a tracking cookie, we could find someone to match it up and get the personal information. So be careful using that term, anonymous. One of the big changes is data subject access rights. Right now in the US, some individual calls you up and says, I want to know everything you know about me. I want you to change it. I want you to delete it. I want you to deliver it to me. You don't have to respond to that. Now, if your privacy policy made a commitment, you do. But by law, you don't really have to respond to that. This is going to be law now in the EU, that you have to have a process to respond to these data subject access rights. And I guess restrict processing is so important that my marketing people put it up there twice. But some of the key things there that people are talking about is this right to be forgotten, this right to erasure, that an individual has the right to contact you and say, delete all of my data. Or this right for data portability, that someone can contact you and say, I want all of the data you have on me so I can go someplace else. The idea was that someone could call up Facebook and say, I want all the personal data you have on me, I want my postings, I want my photos, and I want to take it and go someplace else. I don't know where else they're going to go, but that's the concept, that they can take it. So you need to have a process in place to respond to these requests. Client-vendor relationships are changing because everybody's either a controller or a processor. And you should have an agreement in place between the two of you which states how you're going to use the data. If you're a controller, you want to have an agreement with your processors telling them, this is how you can use my data and no other way. And if you're a processor, you want the instructions. You want your controllers to say, how am I supposed to use your data? You tell me, and I'll follow your rules. Lots of internal policies and external policies. This is making everybody draft documents left and right. I'd like to extend my thanks to the European Union. This is now the Full Employment Act for lawyers. It's keeping us all quite busy. But in order to do all of this, you have to have policies. And compliance people love policies, lawyers love policies. You need to have internal policies about how you control the data. You see down there breach notification. You're going to need a breach notification policy. You're going to need to have new privacy policies to explain to people how you're processing the data. You may need to have new landing pages in terms of consent. There's a lot you need to do. The breach notification, that's very new. In the United States, very recently, the 50th state came on board, but all 50 states have security breach notification laws. How many of you have gotten a notice at home about your personal data being breached by some vendor or some service? Yeah, we've all gotten that. That concept didn't exist in the EU. So this is actually the rare instance where a US concept is being ported over to the EU. But in the US, most of the laws say you just tell someone as soon as you're able. There are now some laws that say it must be within 30 days. EU says 72 hours. 72 hours to notify the regulatory authorities. If any of you have ever been through a data breach, 72 hours is like light speed. I mean, within 24 hours, you're lucky if you organize a conference call with the IT people and the legal people and your PR people and even understand what happened. And that's already a third of the time is gone. So you need to have a good process in place now for security breach, because when it happens, you don't have time to sit there and come up with a process on the fly. Record keeping, there's actually an obligation under the law to keep records of your processing activities. So you need to think about some process. If a regulator came along and said, tell me how you process personal data, you need to have actual records to show how you process personal data. We've been talking about GDPR all the time, and I don't want to scare you even more, but there's another law coming down the pipe which could be even worse. And that is another directive called the e-privacy directive. And under that one, that's in the yellow, that deals with storing or accessing data on a device. Whereas GDPR is this broad concept of processing, e-privacy is just about storing information on a device. However, the very scary part is it requires consent. There's no legitimate interest wagon you can hitch yourself to. It's just consent. It's not been enacted yet. They're still working on it and working on an effective date, but that could really change things. So again, if you're thinking about relying on legitimate interest, keep e-privacy in the back of your mind, because it could change the way things happen going forward. So as I said over and over again, radically different approach between the EU and the US. Sometimes it just makes you think, why are they so uber focused on privacy in the EU, and there are other things they're not as focused on. And I love this tweet by someone in the industry. He said, to my English followers, you can order drugs or hookers from a menu in Holland, but you can't drop a cookie online. It is kind of wacky how they are just so focused on privacy sometimes, considering other things in our lives. So what's happening in the US? There is legislation that may come out of this. And I tend to think, and maybe I should rephrase this, I've always said that I tend to think more legislation will come out of the states than out of the federal level, because I think, in Congress, a little more dysfunctional, hard to agree on a particular legislation, although after the testimony of our friend Mr. Zuckerberg a few weeks ago, it's starting to change attitudes a little bit. The other day in the hotel room, I was turned on TV, was watching a little fake news, and saw one of the senators refer to Mr. Zuckerberg, and they said, he is very smart and he's fluent in BS. So they are thinking about doing things. But as I said, we've mostly been worried about the state level, and things are happening. This law, not enacted yet, but Vermont has been proposing this Data Broker Protection Act. And you might think, well, who's a data broker? And as I said to you earlier, lawyers like to focus on definitions because that drives the law. And this definition of a data broker, a commercial entity that collects, assembles, or maintains personal information concerning individuals who are not customers or employees of that entity. Think about it. Is there any data you have in your organization that is not data of your customer, your direct customer? Yeah, probably. We're all probably data brokers in some way. And this law would require data brokers to register with the state. Wow, that's a big change. Data brokers don't go out and tell the world who they are, and must deliver annual reports to state on their activities. That would be a big shocker. Again, if every company that might have data on somebody else has to report to the state what they're doing with that data, that could be a big game changer. It's still in committee, has not been enacted yet, but these are the types of things that legislators are thinking about. On the federal level, things are happening. This Consent Act has been proposed. It's proposed by 2 Democratic senators, so it may not go too far until it gets a Republican co-sponsor. But it has the typical notice and choice approach for personal information. Notice and choice is more of an opt-out world. But it requires an opt-in world for sensitive customer proprietary information. All right, that didn't seem too bad. Sensitive information, social security numbers, whatnot, that ought to be opt-in. But again, definitions. They define sensitive information as web browsing history. That's a big game changer. If that law passed, you would need opt-in consent to collect web browsing history and app usage history. That really changes the way that business is conducted. And again, it actually throws in breach notification on the federal level, which would make things actually a little bit easier in the United States. I don't have a slide on the latest ones because things are moving so fast, but after the hearings with Mr. Zuckerberg, there is a social media privacy act that's being proposed. and it borrows a couple of concepts from the GDPR, and it is co-sponsored by a Republican and a Democrat. So we really got to watch this because, again, it could change the way that information is being used by organizations right here in the U.S. With that, I'll give you one last piece of advice. I said earlier, don't be creepy, and that's definitely my major advice when it comes to privacy. Don't be creepy. This is a coupon from a little burger place near where I live in New York. It's one of those new, trendy burger places. And I went in there just once, figured I'd try some burgers, and I got them, and they were great, and went home, hadn't gone there again. But then I got this coupon in the mail, and it came in the month of my birthday. And I'm thinking to myself, how did this burger place know my birth date? I just bought burgers there once. Well, how did I pay for my burgers? Credit card. Swiped my credit card. So they must have been working with some data matching company that would match that information up to identify my birthday. Now, I hope that they only got the month and didn't get the day or the year. But I was thinking about this. I'm like, I didn't get any notice about this. You know, there was no consent for me for this data sharing. I'm a privacy attorney. You know, this kind of bothers me a little bit. I went back and got my free burger, though, you know. I'm not a fool. But you want to think about what you're doing. Can it be a little bit creepy to someone? Is there some disclosure you can make to somebody? Or on the back end, if I'm going to do a project with somebody, do I want to make sure that they have good controls? How did they get this data? What are they going to give me? And I hope, again, they don't need more information than just the month and the mailing address. And with that, I'm happy to take all your questions, but again, I'm sure you guys know GDPR inside and out right now because it's a piece of cake, right?
Yeah, I don't, for sure. Yeah, Gary, I have a bunch of questions, actually, and I don't want to maybe ask all of them. But so how are they going to enforce this in the EU? Like, do they have like a SEC-like kind of body to kind of go out there and start taking people down? Or? So
it's a good question about enforcement. Now, the individual countries sort of have like the equivalent of their FTCs. They're called data protection authorities in the individual countries. And so they can go and enforce this. What I'm hearing from my friends in the EU is that one of the requirements on the GDPR is that depending upon your activities as a corporation, you need to have a data protection officer. Oh. And all the people are leaving the data protection authorities to go become data protection officers. So there's a brain drain going on. Okay. So in terms of the physical people who are there to do enforcement, that could be an issue. But don't let that stop your compliance. Then the other part maybe of your question is, well, what if I'm a company sitting in Ohio and I have no office in the EU, I have no personnel in the EU, you know, are they really going to come and get me? You know, you might not be the first target. You know, they may not hop on a plane and come to Columbus and bring the first lawsuit there. It's more likely going to be entities that have a presence in the EU, but that really doesn't change the compliance obligation.
Right. Are you expecting a wave of lawsuits on May 25th? Like just a bunch of big companies, like news coming out right and left about big companies getting sued?
On stage, when regulators speak, they say May 25th, here we go. Okay. You know, enforcement starts. In reality, it remains to be seen if they have the resources, if they're going to go a little light when they start. But again, you've got, you know, a lot of, you know, member states in the EU, and you may have a data protection authority that wants to get aggressive right away. So it's going to be interesting to see what happens.
Okay. All right. I see a bunch of questions over here. Oh, there's also a roundtable on this.
Yes, I get
so
to
we can only
talk
take
about
a couple
this all day
questions,
long.
but yeah. Here, go ahead. Just remind us who you are and where you work.
Steve, working with Outbrain. You mentioned consent and user consent a bunch. When a user opts in or provides consent, what does that window time frame look like? Is it for an infinite amount of time until the next update, or how does that work?
Yeah, good point about consent. There is this idea that consent needs to be refreshed. It's not a specific requirement, but you know, if someone consented to something and you do nothing with that consent for 5 years, and then you start to act upon it, you know, there's an argument that, well, is the consent still valid? Because does the person really know what you're doing? So there is some language in GDPR and the recitals, more likely, about refreshing and keeping users updated about your privacy practices. So I would not take a consent, put it in your back pocket, and then think I'm done forever. You need to continually look at your practices and see, is my consent still relevant to what I'm doing?
Question over here.
Brian Benavides from Apt Electronics.
Hi. There you are. I was looking around the lights. I'm like, heard a
Do you have
voice.
any recommendations for any brands or retailers that don't market or sell overseas, that we just focus on national sales?
So if you're just targeting the U.S., there is language, not in the actual law, but in the recitals, that says like the mere accessibility of your website to people in the EU should not trigger an obligation. But I would say, to look at your practices because, I say the mere accessibility, but if you are like a publisher and you just distribute newsletters and you analyze your traffic and 25% is coming from the EU, I would say it's not the mere accessibility of your site. You really are sort of targeting them at that point. But if you are just focused on domestic activities, domestic sales, you don't ship any products to the EU, you're not targeting people intentionally in the EU, you have no offices there, the fact that an individual in France came to your website should not trigger obligations to comply.
Okay, actually, I think we have to wrap, Gary, but that
All
was
right, not a
great. Thank
problem.
you so much. You know what, folks? Very bright lights. Yeah, no, there is going to be a roundtable on this subject, so anyone who has further questions, and Gary's going to be leading the roundtable, so, at the end of the morning, definitely check that out.